As you guys know, the real estate market is going crazy in Canada wide, especially Toronto and Vancouver side, right? Interest rates are going up, values going a little bit down, and then appraisals are coming short apparently. And some people just having really hard time to close on their properties. And I've been asked about this question: what if we don't close on the property, resale, new builds, and even if you have assigned your contract to somebody else? And what if they don't close? So we have Nikhil to get those answers today. And he actually graduated in law school, and he started his own firm. And then I'm going to pass the mic to him.
Thank you for the kind introduction, Mavi. So as Mavi mentioned, I have been a lawyer for about 7 years. I practiced primarily in real estate law. After practicing for about 7 years, I decided to embark on the journey of becoming a realtor. Real estate always, was of interest to me, which is why I chose the law aspect of it. So I've been doing real estate as a realtor for about 2 years now. Joined EXP back in approximately May of this year. Enjoying the process, meeting a lot of good, intelligent people like Mavi.
Thank you,
but yeah, thank you for having me.
What if you bought a property from builders directly and then you failed to close on that property? So what could be the legal side on that part, and what could be the consequences that you can face in that scenario? So let's start with the first one, Nikhil. So if you can highlight somebody who who bought a resale property, the appraisals are coming short these days. What if they fail to close on that property? What happens after?
Yeah, that's a great question. Unfortunately, we are seeing a lot of appraisals come back less. It's not like how it was a couple months ago where prices were just kind of through the roof. Values have definitely gone down, as most realtors know. And again, this is not legal advice in any way. I would definitely recommend you continue to make agreements, contingent upon financing. But in those cases where your appraisal does come back lower than what the purchase price is, unfortunately, you have to come up with the funds. Now, if you have a hefty deposit on the line, you could actually lose that deposit. And the market that we're in right now, prices are going down. If somebody has to resell that property for a loss, they could potentially come after you for that loss. They could sue you for the difference. So hypothetically, if you buy a house, or let's say you sell your house for $750,000, again, this is just a hypothetical, and then you end up reselling it for $700,000, you've taken a $50,000 loss. Now, the original purchaser that was supposed to close on it, they might be responsible for this $50,000 loss, and you're going to forfeit your deposit. So that's kind of what you're going to start seeing in the market. It's unfortunate, but it's just kind of where we're headed right now.
Is it only somebody can sue you, or there are some other consequences too afterwards, or like how could it impact somebody, like if somebody gets sued?
So lawsuits can take years, obviously, but the main thing is you're going to lose your deposit. So let's say you've put a $50,000 deposit down, right, on a resale property. You could forfeit that deposit. So not only are you losing that deposit, you open up yourself to a lawsuit. If somebody sues you, they could potentially go after you for their legal costs. Let's say they were selling to buy a property and then they incur losses because of that. It's not guaranteed, but they could try to impose that cost that they've suffered as a result of you not being able to close on you. There's that fear at the end of the day in this market that these things can happen. So that's why it's a good idea to get appraisals done beforehand. Definitely make it contingent upon financing, and just be wary of the changing conditions in the market, because we're not where we were a couple months ago. Yeah, no, that's great. And how long it takes to, like, once you get involved in like a lawsuit, how long it takes to get a settle? So that's a great question and kind of a gray area. Lawsuits can take 1 year, 2 years, 3 years. Normally you have 2 years under the statute of limitations to issue a claim, but there's so many factors that come into play. Discoveries where you're gathering evidence. Lawyers have to get involved, obviously. So it can take years for you to actually, get what you're asking for in a claim. That's why a lot of lawsuits settle, which is why they call settlements. No one's really happy, so you may not get exactly what you wanted, but you may get some amount to cover whatever you've lost, right? So something's always better than nothing. But to answer your question, it could take years.
Take years. So, and there could be another expense. You have to go find those lawyers and pay like big amount of fees to those lawyers to just cover up, right? So like that's another thing you have to take into consideration. Like if you're a seller and you're selling at a loss, is it really worth it?
at like, well, is the deposit enough to cover your loss? And if you're going to retain a lawyer, that's going to cost you a lot of money because most lawyers charge hourly. And if you're spending all this time and money on lawyers, are you going to actually be able to, break even? So at the end of the day, it really it's a cost benefit analysis. Sometimes a deposit is enough to cover your loss, but if it's not, then the lawsuit route might be your best chance to recover.
So let's move on to the next question. Let's say somebody bought a pre-construction project. As you have seen the market from last 2 years, everybody was like, let's buy those pre-constructions, like, make a lot of big profits. Some people actually did, like, who bought like even before the pandemic, right? But there was a rat race. Like, everybody's trying to buy those pre-construction. This is the best investment on the earth. And now the thing is, like, some people just trying to sign those contracts, and then as we see in the market, just flooded with assignment sales right now. And some people actually who already assigned that contract to somebody, and what if that person fails to close on the property? What happens next?
So pre-construction can be a little bit tricky because it's not like resale where you're dealing with a simple ORIA form. Pre-construction contracts are usually drafted by very, very savvy lawyers. So you have to be careful. You should always get your pre-construction contract reviewed by a lawyer. Usually there's the common things like capping your levies, making sure there's an assignment clause, but there's a lot of other additional fees that can get passed on to you. But now back to your question in terms of assigning the contract. We've seen contracts where you're signing an assignment agreement with the builder. So there's 3 parties involved. There's the assigner, the assignee, and the builder. Now, let's say the assignee fails to close with the builder. If in the assignment agreement there was a provision that holds the original purchaser, the assigner, liable, the assigner could be held liable if the assignee doesn't close on it. Now, I mean, that may seem unfair because the assigner is assigning all his rights to the assignee. So this should be between the builder and the assignee. But once they put in that provision, you're also binding the assignor and saying, you know what? I sold you this property, and if the assignee doesn't close on it, I need to hold somebody responsible for this. And it could definitely occur in this market right now because obviously prices are going down, and builders want to be protected, so they have to protect themselves too. So you have to also look at it from the builder's point of view.
So are they like 100% liable for the closing, or? It
really depends whether the builder had the provision in the assignment agreement. If there was a provision that could hold the assignor liable, then the builder could potentially go after the assignor for whatever loss that they've incurred. What you saw the last couple of years where prices were increasing so rapidly, where a lot of builders were giving people chances or extensions, or they would say, you know what, it's okay, we're going to keep your deposit, and then they'll sell for a higher price for what they sold it for a couple of years ago to the original purchaser. So now obviously, like, builders, if they do put a provision in that can hold the assigner liable, and they do suffer a loss, they could potentially hold the assigner fully liable for the assignee's breach. Right. If that provision is in the contract, right?
So they design a new contract. Yes. It's not the original contract. It's a new contract. So you gotta make sure, like, your lawyer read that contract as well, right? Just to make sure, like, what are the conditions, what are the consequences you can fail in, on good, bad, ugly side, right?
If you're assigning your contract, normally there's 3 contracts involved. There is the original agreement of purchase and sale. So let's say I'm the assignor. I basically bought this condo 3 years ago from builder A. Right? Now I want to assign that. So first you need consent from the builder. Builder gives me consent, whether it's in writing, whether it's via email, I have consent now. Next step is usually an assignment agreement that you get drafted with your realtors, which is on an ORIA form, right? So that goes over like whatever profit you're making, whatever deposits were given to the builder. So now you have 2 contracts, the original contract with the builder, you have the assignment agreement, and then you have another agreement usually which the builder says, this is our assignment agreement. We need the assigner, the assignee, the builder are going to sign off on it. And these are additional provisions that are going to be imposed on all the parties. So now you have 3 contracts.
So you're dealing with 3 contracts.
3 contracts.
3 contracts, and then I think because they put in additional clauses in there just to cover all the situations.
In the third
just in case.
Yeah, if it's not in the original, then it's in the 3rd contract.
Third contract.
So what I always suggest is, like, if you're buying a pre-construction property, make sure you definitely get that agreement of purchase and sale reviewed. If your intention is to assign it, get the assignment agreement on the ORIA form also reviewed. And then third step, if there's an assignment agreement where the builder says, hey, I want all parties to sign this new assignment agreement, get that also reviewed by a lawyer. Get every single document reviewed by a lawyer, because once you sign, you're bound.
So it's on your due diligence as well. Like, just find a lawyer, sit down with them, and then review the whole contract clause by clause.
So for sure.
Don't leave it on your lawyer as well. Just tell us what needs to be done, like what needs to be. Some people don't cover that part. Like, some people just don't get back to you with those clauses. It's a big contract.
No, definitely.
Right? Like, if you paying some lawyer just to get it reviewed, make sure you sit down with them and just go clause by clause, because sometimes normal people, people, they cannot understand the language that they use in contracts, right? And sometimes it happens, you just give the contract to the lawyer, and then lawyers are like, oh, I'll take a look, and then everything looks good. Did you review it? It has happened to me, like in some scenarios, like, did you sit down with that lawyer and I'm gonna pay you hourly, review everything with me, sitting down with them.
What I would suggest is, like, you should always go to a lawyer who specializes in real estate. Some lawyers, they have many practice areas: real estate, family, litigation. It's always a good idea to go to a specialist who focuses on real estate law. The firm that I was a part of, where I was a partner, Nikhil Bajaj, still existing firm. What we usually did with our clients, and I'm sure it still happens to this day, is that you sit down with the client, you explain to them just kind of a summary of what pre-construction is and the normal provisions that builders put into their contracts. And then you dissect the whole contract, and then you go over it with the client. So whatever's alarming in a contract from a lawyer's point of view, you're going to bring up those specifics with your client. Now, going through the whole contract, it's time consuming, but you're making a huge purchase. It makes sense to dissect the contract and go over it.
Obviously, it's not like when you're buying a $500,000 one-bedroom condo, just to spend like $3,000 extra just to get it reviewed, or whatever you guys charge, that person in the right position for them to buy this property, or their investment. And so now moving on to the third one. So let's say somebody who actually bought a pre-construction house, condo, or any sort of investment from the builder directly, and then they fail to close on the property bought from the builder. So what are the consequences on that part?
So I think I touched on this briefly, but I'll elaborate a little bit on this.
Sure.
So this is the original purchaser buying directly from the builder, correct?
Yes, exactly.
So I mean, if you fail to close for any reason, let's say your financing doesn't come on time, or as you mentioned, that your appraisal comes back less. I mean, at the end of the day, the builder has recourse against you, right? You would forfeit your deposit most likely. In this market, if prices have gone down, the builder can actually sue you for the difference. And at the end of the day, builders also take a risk on building a project. Cost of materials have gone up as well. So for them, it might be, okay, not only are we taking a loss because we put so much money into this project, we're also taking a loss because now there's been a decline in the market and prices have gone down. So they could sue you potentially for the difference. Will they? It's really up to them, right? If they can somehow recoup their money by relisting it, or selling it for a higher price, or breaking even, and they do a cost benefit analysis and say, you know what, it's not worth proceeding, it's not worth suing this person because it's going to cost us more money and time. So they could sue you potentially, and it's more likely to happen in the market, like the market that we're headed towards, right? So it's definitely a huge risk not being able to close with the builder. So I would say that make sure, if you have a pre-construction project that you're closing on within the next couple of months, talk to your mortgage broker, go over the scenarios, low appraisals, go over the scenarios where interest rates are going up. You're at the end of the day, as rates go up, the amount that you're approved for also, it goes down essentially, right?
Exactly.
So it's definitely a scary position to be in, but if you're you're anticipating that, you need to prepare at the end of the day, whether it's borrowing money from family, from friends, taking a line of credit, work with your financial advisor, your mortgage broker to find a way to close on it, because the last thing you want to do is, default on your purchase with the builder. You can't sleep at night because you're like, okay, this builder might sue me, come after me, and then boom, you're hit with a lawsuit. That's the last thing that you want at the end of the day.
And what are the costs that you can face if you get involved in a lawsuit?
I mean, you're saying that if you hire a lawyer?
Yeah, I mean, like, let's say you fail to close on a property, so you lose your deposit, and then the builder can sue you for the difference. And what are the other costs you might see, like, on that?
So sometimes they might charge you for their legal costs because they wouldn't have had to sue you, or they wouldn't have had to sue you if you didn't breach your agreement with the builder. So they can go after you for legal costs, admin costs, any costs imposed on them for you being in breach of that original agreement.
And there's no cap.
I mean, you can't charge fees that would be unconscionable in the sense that where like a court looked at it and said, wow, these are inflated fees. I mean, which, when I was doing litigation at the beginning of my career, we used to do motions for costs, and sometimes people would look at the cost breakdown and kind of want it dissected and see whether or not they were reasonable. If they're unreasonable costs, then no judge would probably rule in favor of that. They might say that, you know what, these legal fees of $150,000, they didn't make no sense. But if they're reasonable costs and they put time and effort, and let's say the lawsuit went on for years, then they can impose those legal costs on you if they win.
I don't know. I have another question. It just came out of my mind. So, if you get sued, does it impact your credit report as well? Does it go in your credit report that you were sued? Like,
I mean, this is like more of a question for, I guess, like a credit bureau. But based on my limited knowledge of this, let's say that they sue you, and then they get a judgment against you, and you have to pay the builder. Let's say you don't pay the builder. Well, they could technically, put a judgment against your name and say that, this person owes this amount of money. And let's say I go to buy a house, that judgment can actually come up on your credit score, and also as an execution against you. So as lawyers, when you do title searches, what a lot of lawyers do, most lawyers, if not all, they do something called execution searches, and that checks to see whether there's any judgments against a purchaser or seller. So if somebody's selling a house, lawyers normally do an execution search, and they can actually see if there's any judgments against that person. So we always used to do execution searches to see whether there's judgments against, seller A, seller B, but we would also do them against our clients, because a lot of times we're representing the bank when someone's buying. So it could definitely come up. If you haven't paid.
In this country, man, like. You don't want to screw up with your finances.
Maintain your credit.
Maintain your credit. Like, once it goes on your credit report, like you can get any sort of loan or any sort of any sort of asset or any sort of lending. Right. But thank you so much for your time, Nikhil. It was a really good topic to explore.
If anybody has any legal questions, which I'm not allowed to do because I'm not a lawyer anymore, you can contact Nikhil Bajaj. It's the firm that I was associated with. I was a partner there. My business partner Ikber Kangura still is the managing partner at that firm. He's been doing real estate for the last couple of years. Very knowledgeable guy. Has litigation experience as well. But I would say that we're heading towards I wouldn't say it's a dark time. It's just going to be a different time next year. It's something that I feel like this topic was important because people need to protect themselves as realtors, as clients.
No, actually, I mean, like, it's your duty to speak up not only the bright side, but tell them like what the other side looks like. So you prepare like for both situations. So just in case, so you may, I think when you talk about the both sides, it helps somebody to make a better decision.
Definitely, yeah.
So good sides and bad sides, and then we want to take this risk, and we are fully aware of what we're getting into. Right?
For sure, yeah.
And thank you for your time, Nikhil. I appreciate your time.
Yeah, thank you.
And we'll talk again on this.
Appreciate
topic.
it.
Thank you, guys. Bye bye.
Take care.